everyone, welcome, and let us now discuss Title 2, Incorporation and Organization of Private Corporations. I just wanted to show you the Jiffy. What is incorporation? Incorporation is the performance of conditions, acts, deeds, and writings by the incorporators. Since a corporation is only a creation of law, there is no innate right to incorporate. It is only a privilege granted by the state by virtue of the revised corporation code. Because of this, individuals or other entities who wish to create a corporation must comply with the formal requirements stated under the law. Now, as to a certificate of incorporation, we will discuss this later, but it is important to note that a corporation only commences its juridical existence separate from its incorporators and stockholders upon the issuance of a certificate of incorporation by the Securities and Exchange Commission. Please note that before, what was required was for people to print copies of the documents that they need to submit with the SEC, personally go there and file the same. However, because I mentioned the corporation code was revised to increase the ease of doing business in the Philippines, we are now allowing electronic filing by the SEC. Now, the SEC already gave rules and regulations on how to comply with the electronic filing requirements. So, for those of you who would want to incorporate, actually as early as now you can, given that everyone's above the age of 18, all you need to do is go to sec.gov.ph. So, when you go there, this is what you will see, the SEC Company Registration System. It's extremely easy to follow naman. Now, what are the documentary requirements? It would depend on the type of corporation. If one is to form a stock corporation, what is required is the name verification slip, because you need a corporate name first before you file your other documents. Otherwise, there's no name that you can write on the heading of the articles of incorporation and on the heading of the bylaws. And 2, you need the articles of incorporation, which we will discuss in a few minutes. 3, the bylaws, and 4, additional requirements. Now, what are these additional requirements? For stock corporations, these would be endorsements or clearances from government agencies, if applicable. For corporations with foreign equity, proof of remittance by non-resident aliens, and a registration of their investment with the BSP. Now, if they don't want to register their investment with the BSP, it's okay, as long as they file an affidavit stating that they will not register their investment. Now, why do you need to register? Generally because it's a way to monitor the investments from foreign entities. 3, for corporations with more than 40% equity, an application form from the an application form in compliance with the Foreign Investments Act. And number 4, for corporations with applications in economic zones like PEZA, SBMA, CDC, the Clark Development, or CEZA, the Cagayan Economic Zone, you need a certificate of authority or endorsement from these agencies. And for corporations that need to comply with the nationality requirements, I will just read Attorney Laco's notes. For mass media corporations, 100% must be reserved to Filipinos. For advertising corporations, 70% must be reserved to Filipinos. And for public utilities, educational institutions, exploration, evaluation, and development of natural resources, and ownership of land, these corporations must be at least 60% reserved to Filipinos. So it can be more. For non-stock corporations, the first 3 are the same. 1, a name verification slip. 2, to submit your AOI or your articles of incorporation. 3 is your bylaws. 4, a list of members certified by the corporate secretary unless these members are already named in the articles of incorporation. 5, the list of contributors or donors and the amounts as certified by the treasurer. Now, there is an asterisk because if the non-stock corporation to be formed is a foundation, the minimum contribution or donation must be at least 1 million pesos. For other types of non-stock corporations, there's no particular amount required. Number 6, the registration data sheet, and of course, number 7, additional requirements. What are these? For foundations, a notarized certificate of bank deposit of contribution stating that there is at least 1 million pesos, and a statement of willingness to allow the SEC to conduct an audit. So I think that already includes a waiver of the bank secrecy law, because syempre the SEC might want to verify if really there is at least 1 million pesos. For religious corporations, there are requirements under sections 109, 110, and 114 of the Corporation Code. And aside from the requirements under 109, 110, and 114, there's also a requirement to file an affidavit of affirmation or verification by the chief priest or rabbi. Number 4, for federations, a certified list of member associations by the corporate secretary. And number 4, for condominium corporations or associations, a master deed, and a certification that there's no other existing condominium association within that condominium project. So note, before I discuss about the names, articles of incorporation, and the bylaws, etc., you will notice that the words incorporation and organization are used interchangeably, and rightfully so. However, when you go to section 21 of the Revised Corporation Code, you will notice that the word organization has a different meaning. What do I mean by that? Under section 21, it talks about effects of non-use of corporate charter and continuous inoperation. Under section 1, it already contemplates corporations that were already incorporated. So when it mentioned there, if I may just refer to the section quickly, section 21, if a corporation does not formally organize and commence its business. So here, the word organize does not mean incorporate, because under section 21, it contemplates corporations that were already given a certificate of incorporation, but the corporation itself did not do anything after. Either that, or it already commenced business, but it stopped for 5 years. So we will discuss that later. Again, but I just want you to know that there's a difference between incorporation and organization when you read section 21. Since we discussed the requirements for stock and non-stock corporations, one of the identical requirements is a name verification process. Before, under the old corporation law, meaning BP Batas Pambansa bilang 68, what was required was that a corporate name is not confusingly or deceptively similar. Those were the exact words used. The problem with that was the name verification process with the SEC took longer because it's difficult to establish what is confusing. Since a confusing similarity is actually a subjective term. Now, under the Revised Corporation Code, what is required, as previously mentioned, is that a name is distinguishable. If you remember what I just mentioned earlier, a corporation, say ABC, ABC Hospital, can be registered even if there is already ABC Restaurant, because what is distinguishable are the words hospital and restaurant. Okay, now let's look at section 17, corporate name. No corporate name shall be allowed if it is not distinguishable, as I've already mentioned, from that already reserved or registered for the use if another corporation, or there's another prohibition, if such name is already protected by law, rules, and regulations. Okay, and so it is not distinguishable even if the corporate name contains the words corporation, company, incorporated, limited liability, or any abbreviation of such. So it's here in letter A. Another thing is punctuations, articles, meaning the word, what are articles? The, a, an, those words. Conjunctions, contractions, prepositions, abbreviations, different tenses, spacing, or the number of the same word or phrase is also not a distinguishing word. So once the commission determines that it is not distinguishable, or it's already protected by law, or it is contrary to law, the name is contrary to law, it may summarily order the corporation to immediately cease and desist. Why is the word summarily important? Because it means that the SEC need not hold a hearing. On its own, it can just order a cease and desist. For cease and desist from what? From using that name in business. So the commission can also remove any visible signages, marks, or advertisements, label prints, and other effects bearing the name. Now, once your corporate name, or a corporation's name rather, has been declared not distinguishable and a new corporate name was submitted, the commission can now issue a certificate of incorporation under the amended name if that amended name is distinguishable. As I mentioned earlier, under the revised corporation code, corporations now have criminal liability. And the first section that provides for a criminal liability is the violation of Section 17. If a corporation fails to comply with this, it may hold the corporation and its responsible directors and officers in contempt and or administratively, civilly, and criminally liable. What would be the criminal liability there? Under Section 159 of the revised corporation code, it states that the unauthorized use of a corporate name shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. Okay. Let me just give a few notes about Section 17. The corporate name is different from a trade name. A trade name is what is usually used when transacting with other entities. If there is a corporate name and a trade or business name, so trade and business name are the same, If a corporation has a separate trade name from its corporate name, there are some documents that still need to indicate the corporate name. Usually these are the official documents like general information sheet, obviously the articles of incorporation, it is required under Section 14. I think if you're filing with the BIR, it's also needed. No? So just take note that a business name is different from a corporate name. In any case, business names still need to and corporate names still need to comply with other laws, like what? The Intellectual Property Code. So I will not delve too much into that. I just want to mention that if you're talking about the Intellectual Property Code, usually what is required for a business or corporate name's registrability is the dominancy test. If you notice, for example, McDonald's and McDonald's, if you look at it, even the letterings are the same. There are also other cases, I will not mention anymore in the interest of time, where the Supreme Court ruled that if you look at it, dominancy test, meaning if you look at the logo on its own, it really looks like the name was created and the logo was created to make it look like it originates from the other corporation. I mentioned earlier that one of the reasons why the revised corporation code was passed, was to harmonize the powers of the SEC under the Securities Regulation Code and the Corporation Code. So when you look at Section 17, it shows that the SEC has exclusive jurisdiction when it comes to corporate names. So the SEC now can deregister a corporate name. When I say deregister, it means that if a corporate name was initially valid and a law was subsequently passed declaring it illegal, then the SEC has the power to require that corporation to change its name. Why would the corporation be bound? Because it is required, and we will discuss later, that the corporation execute an undertaking, an unqualified undertaking, promising to change its corporate name if it is needed, like if it's not distinguishable or if it is against the law or morals or customs. Yan. What would be the guidelines when it comes to corporate names? As I've mentioned earlier, and I will mention it now, there is SEC Memorandum Circular number 13 series of 2019, which are the guidelines on the use of corporate and partnership names, actually. If I may just mention briefly, because it's quite a long memorandum circular, it states here, like, a corporation shall contain the words corporation or incorporated or corp or .inc, if you remember that. If it's a one-person corporation, the corporate name shall contain the word OPC either below that corporate name or at the end of the corporate name. If it's a foundation, it must state the word foundation. If it's microfinancing, it must have those words. And if it describes a business, then the corporate name's description must refer to its primary purpose. If there are two terms, then the first term should be for the primary purpose and the second for the secondary purpose. If the name is similar to a corporate name before, it wouldn't be allowed if it's confusingly similar. Now, it's allowed if that corporation adds one or more distinctive words. So, the keywords are distinguishable and distinctive. However, if the addition of one or more distinctive words is coined or unique, then adding it is still not allowed. No? Okay, this is interesting. A name that consists solely of special symbols, punctuation marks, or specially designed characters shall not be registered. Common sense dictates that it is not registrable because how can you actually call a corporation swastika, exclamation point, skull, diba? So, ang maganda na, the beauty about law is all about logic and experience. Okay. Here, note this. A single stockholder of a one-person corporation may use his or her name. What does it mean? He or she can actually use the name of another as long as there is consent. And if initials are used, it shall be stated in the articles of incorporation as to what those initials mean. Name of a local geographical unit cannot be used as a corporate or partnership name unless it is accompanied by a descriptive word. And the SEC circular give an example. For example, Pasay. It cannot be registered unless you state Pasay Food Store Inc. I will not go over the others naman. Oh, under Republic Act, diba, I mentioned here that a corporate name must not be contrary to law. One good example is RA 10530, or the act defining the use of the protection of the Red Cross. The words Red Cross, Red Crescent, or Red Crystal cannot be used by law. Yeah. Now, what if a corporation has been dissolved or its registration has been revoked? Can another corporation use that dissolved or revoked corporation's name? The answer is yes, but it must be after 5 years from the date of dissolution, from the approval of the dissolution, or 5 years from the date of revocation. Unless, meaning it can be even within 5 years from the approval of the dissolution or the date of revocation, if it is allowed by the stockholders, members, or partners representing a majority of the dissolved or revoked corporation. So you'll be asking, Miss, why is it that you say that the words corporation and incorporated or corp or inc must be included if it's not in section 17? If you look at section 14 or the form of articles of incorporation, it requires that the corporation's name must include either of those words. Now, can a corporation change its own name? The answer is yes. And what is the effect? It does not create a new juridical entity. It does not end the previous one. It's just a mere change of name. Similar to how people change their nicknames. There's no difference. No. Are corporations who change its names required to notify debtors? The answer is no. It's discretionary. There is no requirement under the law or the rules that a corporation notify its debtors that it changed its name. However, there are some rules that require notification to government agencies like the BIR or the Economic Zone Authorities. What happens or what is required when a corporation changes its name? It must comply with the procedure of it must comply with the procedure in amending the articles of incorporation, and we will discuss that later. Let us talk about the second common requirement for stock and non-stock corporations, and that is the articles of incorporation. Before we move on to the provisions, the articles of incorporation is defined as the charter or the constitution of the corporation, and it defines the relationship between three sets. One, between the shareholders and between the corporation and the state. Two, between the stockholder and the state. And three, between the corporation and the stockholders. So it is submitted to the SEC in order to obtain a certificate of registration, and it is more important than the bylaws. So although it is preferred that the bylaws is submitted to the SEC alongside or with the articles of incorporation, it's more important to submit the AOI first before the bylaws. I think there are instances where the bylaws can be submitted later on, and we will discuss that later when we get to bylaws. So there's a separate title for that. Now, when you say that it is a charter between or a constitution between the state, it means that the state cannot just unilaterally revoke the articles. If the certificate of if the stock and transfer book state a different amount as to how much was paid up, different from the AOI, then the AOI prevails. I will not anymore place the particular provision, Section 13 and Section 14, as I will discuss these simultaneously. I will not place it anymore because it's too long. You can always refer to it through your Canvas account, or for those who cannot access it, you can just type in RA or Republic Act number 11232 or the Revised Corporation Code, and please click on the website of the official gazette because that is our official publication for the country. At least that way, you can make sure that the provision you're looking at is official. Now, when we discuss, I will first discuss Section 13 and 14 because it refers to the contents in the form. While discussing Section 13, we will already discuss Section 10, 11, and 12 because those are parts of the enumeration under the contents. Let me just highlight some parts of Section 13. You will see, under Section 13, it shall be filed with the Commission in any of the official languages. What are these? Under Section 7, Article 14 of the Constitution, you don't need to cite that, I'm just mentioning, our official language is Filipino, and unless otherwise stated in another law, the second one is English. So those are official languages. It must be duly signed and acknowledged or authenticated by whom? The Incorporators and the Treasurer. And I will discuss that later. And it must contain substantially the following matters, alphabetized under Section 13, letters A to J. What does it mean by substantial compliance? Substantial compliance means most of it has been complied with. Does not need to be strict compliance. When you talk about substantial compliance, it means that if the incorporators substantially or comply with most of the provisions as much as they can, it does not affect the de jure existence, meaning the existence by law of the corporation. Meaning there is still a corporation de jure, not de facto. And we have discussed this already in the introduction to the RCCP, no? However, even if there is substantial compliance, there are certain portions of the AOI that must be strictly complied with. So the AOI as a whole can be substantially complied with, but there are some provisions that must be there. What are these? Number one, obviously corporate name. How can you do business with someone with a corporation you don't know how to name? No, it's hard. And number two, a purpose. These are indispensable. So with name, we have already discussed it under Section 17. But let me just go over it. The name is important because it's necessary for identification purposes. It is part of the right under the franchise granted to the corporation. Normally, you can reserve, and it is preferred that you reserve the name first for a limited period after paying the required fees with the SEC. But that reservation does not automatically mean it's approved. It's just to reserve it. I'm sure you know what it means, no? Just so that other people will also be warned not to use it. Syempre, parang first come, first serve. Assuming that there is no name that is not distinguishable. So the name of the corporation need not reflect the purpose. So just take note. So it can be XYZ Corporation. Let's talk about the clause. It's already under section 13, so I will not read it out loud anymore. Please take time, pause the video if you need to read the provisions under section 13. What is the importance of the purpose? It's important to assure investors or potential investors about the type of business that the corporation is engaged in. Other purposes that are not allied or incidental to the primary purpose should be classified as secondary purposes. Why is this important? If you look at section 41 of the revised corporation code, it talks about the power of the corporation to invest in corporate funds in another corporation or business or for any other purpose. Let me just refer to that. When you talk about section 41, it says here that a private corporation may invest its funds in any other corporation, business, or for any other purpose other than its primary purpose when it is approved by a majority of the board of directors or trustees and ratified by the stockholders representing at least 2/3 of the outstanding capital stock. What does it mean? If you are to invest your fund, the corporation's funds, in furtherance of its primary purpose, there is no more need to follow this voting requirement under section 41. As a general rule, the primary purpose determines the classification of a corporation. However, where the corporation actually engages in one of its secondary purposes, it may also be classified in accordance with the secondary purpose. Thus, a corporation is a mining corporation if mining is its primary purpose. Where mining is the secondary purpose, it may be considered a mining corporation only when it undertakes its mining purpose and it's actually engaged in mining. So, just to be clear, if the purpose of a corporation is, for example, to establish, operate, manage, hold, or invest in corporations engaged in mining, okay, that corporation, the one who is whose purpose is to invest in mining corporations, is not in itself a mining corporation. It is just a holding corporation or a holding company. Now, how do we disclose the purpose in the AOI? There should be a specification with sufficient clearness so that you clearly define the scope of your business to enable one to determine who they are transacting with or they are investing in. Meaning, a statement that the object of the corporation is to carry on any business that it may deem profitable is not allowed. I mean, if the purpose is vague, the AOI can be disapproved. When we talk about purpose, syempre we're talking about the powers. Syempre, if your purpose is mining, then the power is to engage in mining operations, subject to the required licenses and permits. The question would be, are all powers required to be stated in the AOI? The answer is no. Not all powers need to be described as, I mentioned this in the previous video, corporation is allowed to engage in implied or incidental powers. So those need not be stated. The purpose clause is not just for investors. It's also for directors and officers. Why? So that they will be informed as to the extent of their authority. It's also for third person, so they know who they are transacting with. What are the general limitations to the purpose? This was already mentioned. The practice of a profession cannot be a purpose, meaning professional groups cannot incorporate for the practice of profession. But if there was a question where attorneys A, B, and C form a corporation to sell law books, that is allowed. Or accountants incorporate to sell accountancy books or review books, then that is allowed because they are not practicing a profession, they are engaging in trade or retail. One of the general limitations also is is organizing a corporation for the purpose of creating a municipal corporation or a business engaged in prostitution. Also, a non-stock corporation cannot be organized for, stock and non-stock cannot be organized for incompatible purposes. What do I mean by this? Under the general banking law specifically, banks are prohibited from engaging in insurance businesses. A corporation is not allowed to organize for a purpose contrary to its nature. What do I mean by that? Non-stock, non-profit corporations cannot have as its secondary purpose the manufacturing of goods to be sold. But, take note, Section 86 and 87, and I will just discuss this briefly right now to give you a clearer picture. Under Section 86 and 87, it defines a non-stock corporation and gives its purpose. If you read it carefully, it would make you think, wait lang, if you say non-stock corporations are not allowed to engage in something contrary, like into retail, why is the word trade allowed here under Section 87? It is allowed to earn income, number one, if it's a non-stock corporation, so long as no part of its profits is distributed as dividends to its members. Even if there is a statement of capital stock, the corporation is still non-stock if dividends are not supposed to be declared, because you're looking at the true nature of a corporation. When I talk about the purpose, while they are not allowed to generate income, it is allowed to venture into a profitable business as an exception, meaning only if it's incidental to its operations or whenever it is necessary for the furtherance of the purpose or purposes for which that non-stock corporation was organized. What does it mean? The fact that a non-profit corporation earns a profit does not make it a profit-making corporation. Or, if I may rephrase, the fact that a non-profit corporation earns a profit means that it's not allowed. Let me give an example. It may be allowed when earning profits is merely secondary. Say, it earns money and then it invests its profits in order to earn additional income to pay for its operating expenses or to meet benefit claims. That's allowed. Another example, a non-stock corporation that is organized for social purposes may operate a restaurant to cater to its members if the revenues will be used to defray the overhead expenses of the corporation. Similarly, a non-stock corporation can lease a property it owns. A non-profit corporation for religious purposes can engage in retail of Bibles or other religious literature as long as the said activity can be reasonably necessary and incidental to its purpose. So what's the purpose of a religious organization? Say, for example, for evangelization. Part of it would be selling Bibles or any other religious literary work to help its purpose of evangelization. But what it cannot do is it cannot engage in a franchising business, because a franchising business is an arrangement where one party grants another party the right to use its name and to market goods and services, with the franchisee paying the franchisor a fee plus a percentage of its sales revenue. That's not anymore incidental to its non-stock purpose. So I will discuss that more when we go to non-stock. So we're in purpose ha, baka you're getting confused. The best proof of the purpose is its articles of incorporation. If it is lawful, then the Securities Exchange Commission has no authority to inquire whether the corporation has purposes other than those stated in the AOI. What will be the remedy of the incorporators if the SEC does not want to issue its certificate of registration? You can file a case for mandamus with the courts to compel the SEC to issue a certificate of incorporation. This is assuming that the only reason they are disallowing is because they think there might be a purpose that is illegal, but on the face of the articles, the purpose is valid and legal. There can a collateral attack on the legality of the corporation is not allowed. What do I mean by that? There's this case Gala versus Ellis Agroindustrial, where the spouses Gala, that's their last name, no, Gala, they created two corporations, Ellis and Margo, and they placed their the spouses' property, pieces of property. It was an attempt to have the articles of incorporation revoked because they were saying that, the two corporations were only created in order for Gala spouses to avoid estate taxes and to avoid compliance with agrarian laws. Kasi the pieces of property that they invested in the two corporations were actually agricultural property. The Supreme Court said that we don't have jurisdiction to do that. It's actually with the administrative body, which is the SEC. And since the articles of incorporation don't state that that is the purpose, then even with the SEC, you cannot have it revoked generally. Parang ganun na yung sinasabi niya. Now, let's talk about the principal office. Now, it is required that the location of the principal office be specifically identified. So, under Circular Number 3, Series of 2006, if feasible, it must include the street number, street name, barangay, city, or municipality, and the specific address of the incorporator, director, or trustee. Before kasi, it was allowed that the address be Metro Manila, that wide. Now, it's not allowed anymore. The SEC justified why it must be specific. In order to send show cause letters or to send other communications or court processes, it would be difficult if you just stated there Metro Manila. Can you imagine how large it is, no? All existing corporations and partnerships whose address only indicated their general address, meaning those before 2006, are required to amend their articles of incorporation. Otherwise, a one-time penalty will be imposed on them. There is a good observation by Aquino and Aquino. They said that conceptually, there might be a problem with this requirement for a specific address. Since there is no corporation yet, as there's no certificate of registration issued, it would be difficult to enter into a contract since the incorporators are forced to designate a specific place where it will locate its principal office when the corporation has no existence yet. In actual practice, stockholders enter into a contract with the prospective lessor of the property where the principal place will be to reserve the principal office. And such agreement now will expose the stockholders to potential liability or forfeiture of deposit or advance rental if, for example, it doesn't push through. Let me just note, if the corporation's principal address is already complete and specific, but the corporation has moved to another location, but it's within the same city or municipality, you don't need to amend your articles of incorporation. What will you do? You must declare that change of address in the general information sheet within 15 days from the transfer of to its new location. When would you need to amend? Corporation will need to amend its AOI if the transfer to a new address is to another city or municipality. What else are the other reasons why it is important to have a specific address or a principal place of business? It will determine where a chattel mortgage should be registered if we're talking about shares of stocks, because it must be registered at the principal place of business. And unless otherwise provided for, meetings for stockholders or members shall be conducted in the city or municipality where the principal place of business is located. And if practicable, in the principal office of the corporation. Although that might not be so important now, especially since video conferencing is now allowed now. Electronic communication may be allowed in certain instances under the revised corporation code. Under the previous corporation code, what was required was that money for investment for the subscription of stocks and paid up capital must be in legal tender. That means Philippine currency. However, that was removed. What does it mean? Now, we open up corporations to paid up capital in being in foreign currencies. This is actually a good thing because it leads the Philippine economy to globalization. There is an important modification or to the revised corporation code. I don't know if in basic accounting you were all computing for paid up capital. If you remember, authorized capital stock should be declared, 25% of which must be subscribed, and 25% of the subscribed capital stock must be paid up, the 25-25 rule. Under the revised corporation code, there is no more 25-25 rule for its articles of incorporation. But be very careful. There is still the 25-25 rule when you look at section 37. What is that? When you increase authorized capital stock. So when you incorporate, there is no requirement for the 25-25 rule, but if you decide to amend your articles of incorporation to increase authorized capital stock, then the increase must comply with the 25-25 rule. Under section 37, the third to the last paragraph, the Commission shall not accept for filing any certificate of increase of capital stock unless accompanied by a sworn statement of the Treasurer showing that at least 25% of the increase in capital stock has been subscribed and that at least 25% of the amount subscribed has been paid in actual cash, or that property, the valuation of which is equivalent to 25% has been transferred to the corporation. Let's go to the portion under section 13 when it talks about the corporate term. Please cross-refer that or refer to section 11 because it is a significant change in the corporation code. Now, corporations generally have perpetual existence. Under the previous corporation code, corporations will have a life of 50 years unless otherwise stated. Now, it's perpetual existence unless otherwise stated in the Articles of Incorporation. The question would be, what about old corporations? Old corporations automatically also have perpetual existence. No other operative act needs to be done. The exception would be if the pre-RCC or pre-revised corporation code corporations elect to maintain its corporate term, in which case there must be a meeting, the stockholders must vote, there must be majority vote of its stockholders representing its outstanding capital stock desiring to maintain its old term. Although it says here that any change in the corporate term, so whether it's an extension or it's to maintain, is without prejudice to the appraisal right of dissenting stockholders. What is appraisal right? It is under sections 80 and 81 of Article 10. It's when a dissenting stockholder, meaning a stockholder who does not agree, will need to make a written demand for the payment of the fair value of his shares. That must be exercised within 30 days from the date on which the vote was taken. We can refer to the SEC guidelines on corporate term or Memorandum Circular number 22, series of 2020. It is available. Let me just discuss it so you don't need to read it yourself. Number one, it is available to non-stock corporations. It must be approved during the annual or a special meeting for that purpose. Two, it must be approved by the board. Before it will be submitted to the SEC. It must be signed by at least a majority of the members of the Board of Directors or Board of Trustees and attested to by the Corporate Secretary. And there is a limit to the exercise of this option. And this is for existing corporations or pre-RCC corporations. Notice must be submitted within a period of 2 years from February 2019, or as I stated here in the PowerPoint, until February 2021. That's next month. What does it mean? If they don't notify the SEC by February 2021, pre-RCC corporations automatically have perpetual existence. What if, for example, stockholders want to retain the corporate term, but the board members refuse to sign? The only solution to this impasse would be for the stockholders or members to elect a more competent board within that 2-year period from 2019 to 2021. A corporate term for a specific period may be extended or shortened by amending the Articles of Incorporation, but the extension should be made only within 3 years prior to the original or the subsequent expiry date. So it cannot be earlier than that. And the extension will take effect only on the day following the original or the subsequent expiry date. Since we're talking about corporate term, the first question would be, when is the first day of the term? So it's the date stated in the certificate of incorporation. When would be the last day then? It would be the day before the corresponding numbered day of the same month of the incorporation in the last year of existence. What does it mean? For example, a corporation states that the corporate term will be for 10 years. And the certificate of incorporation states that the date of incorporation is, what day is today? January 10, 2021. 10 years then, the last day would be on January 9, 2031. Arrival of the date of the expiration date of the corporation, ipso facto, meaning automatically, the corporation is deemed dissolved. Therefore, a corporation cannot seek for its extension after the expiration of its corporate term. There are exceptions to this ipso facto dissolution of a corporation upon the arrival of its expiration date, and that is under the doctrine of relations or the relating back doctrine. This applies if there is a failure to file the application for extension within the term of the corporation, and it is due to the neglect of the SEC officer whom the certificate is required to be filed. And also, there was a time where, although there was no fault on the SEC officer, the Securities and Exchange Commission was closed during the EDSA revolution. So in those instances, the corporation is not ipso facto deemed dissolved because of no fault of the corporation. What are the guidelines therefore? Or what are the steps that should be taken for the extension of corporate term? For easy reference, number 1, the Articles of Incorporation shall be amended stating the term of extension, and it must be approved by a majority of the board and 2/3 of the stockholders or members. Number 2, the approved amendment of the AOI shall be submitted to the SEC for approval not later than 3 years under Section 11 prior to the expiry date. Number 3, the amendment is deemed approved upon the inaction of the SEC for 6 months after submission, if the inaction is not due to the fault of the corporation. So the effectivity of the amendment relates back to the date of its filing with the SEC. Now, when talking about the revival, under the last 2 paragraphs of Section 11, there are SEC guidelines on the revival of expired corporations passed in 2019. It states there that the corporation must file a petition for revival of expired corporation, and this can be done both by corporations organized prior to the revised corporation code or pre-RCC corporations and corporations organized after the promulgation of the RCCP, Revised Corporation Code. However, there are certain corporations that are not allowed to file a petition for revival. And these are number one, expired corporations that have completed the liquidation of its assets. Two, a corporation whose certificate of registration has been revoked for reasons other than filing of reports. Three, corporation dissolved by virtue of Section 6C and D of PD 1799. You don't need to know that anyway. And D, an expired corporation which already availed of re-registration per circular. Yan. And what is the voting requirement before a corporation may file a petition for revival? There must be a majority vote of both the board of directors or trustees and majority of the outstanding capital stock or a majority of its members if it's a non-stock corporation. If you look at Section 13 under the contents of the Articles of Incorporation, particularly letter E, it states there that the names, nationalities, and residence addresses of the incorporators must be stated. Then if you look at letter F, the number of directors, which shall not be more than 15, or the number of trustees which may be more than 15. Please note that when you look at letter E, meaning the incorporators, you must also look at section 10, which is the number and qualification of incorporators. Similar to the directors during an incorporation, the number of incorporators must not be over 15 as well. The major amendment by the Revised Corporation Code is that now it is not just a natural person who may be an incorporator. Partnerships, associations, or corporations may also be incorporators. When you look at the first bullet point, the incorporators are not the only subscribers to a corporation. Why is it so? Because what is required under section 10 is that the incorporators be at the most 15 only. However, it is also possible that the corporation has other entities, individual or corporations or partnerships that would subscribe to the authorized capital stock of the corporation even before the corporation is incorporated. These people, those beyond 15, meaning they shouldn't be signing the Articles of Incorporation, are still subscribers, just not incorporators. So be careful with that. Another major amendment is that there is no more need for the incorporators to be residents of the Philippines. Note that when it comes to the rule on professionals, natural persons who are licensed to practice a profession and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special law. So the general rule is still that these persons or associations are not allowed. The exception would be if a special law was passed. Rural banks were allowed to be incorporators only to organize another rural bank under the Rural Banks Act of 1992. Under the Revised Corporation Code, corporations can now be incorporators not only of rural banks but also other types of banks like commercial banks and universal banks, provided they are allowed to do so by the Monetary Board of the BSP. And when you look at local government units may also be incorporators. It is believed that corporations under Section 10 include both private and public corporations. Now, when you look at the previous corporation code before, it said there that the requirement was at least 15. That was already removed, especially since now there's already a one-person corporation. There can actually even be two. The purpose of this was to avoid the normal practice of people getting nominal partners just to complete the minimum five incorporator requirement. Does it mean that nominal shareholders are not allowed? The answer is no. They are actually allowed, especially if the incorporators want nominal stockholders. Now, please note that when the incorporator is a corporation, and that corporation, the incorporator corporation, um, is not a is not primarily in the business of being in the business of investing in corporations, then section 41 of the revised corporation code must be observed. What does it mean? If you remember section 41, I mentioned earlier that it requires the approval of both the board and the stockholders or members if the investment as an incorporator is for a purpose other than its primary purpose. If you look at our section 13, article H and I, it would talk about the requirement to state the contributions by non-stock corporations and the authorized capital stock, the subscriptions, and the names, nationalities, and residences of the original subscribers. You would need to cross-refer that to section 12, wherein the minimum capital stock is not required in stock corporations anymore. This is actually in harmony with the deletion of the previous section 13 under the previous corporation code, where the 25% rule was required. If you remember before, where under Batas Pambansa Bilang 68, at least 25% of the authorized capital stock must be subscribed and at least 25% of the subscribed capital must be paid up. That's not anymore required here. Paid up capital may still be subject to different minimum requirements under special laws. So, since the revised corporation code is the general law, then if there are no special laws governing incorporation, section 12 will apply. No minimum capital stock is required. So now, although the submission of a certificate of deposit is not presently required, it is still good practice to do so. So there's also guidelines covering the use of properties that require ownership registration as paid up capital, where in the form of land there must be proof of the transfer of the certificate of ownership, which must be in the name of the transfer corporation within 120 days from the date of the approval of the application, and a 90-day requirement if it's property other than land. If a going concern like a single proprietorship is being converted into a corporation, financial statements duly certified by an independent CPA, that would be you guys in the future, will be needed, as well as the written consent of the sole proprietor's creditors. There must be a deed of assignment by the sole proprietor to the corporation. There is a treasurer certification under the 9th clause of section 14, and it must state the name of the treasurer, who must be elected by the subscribers, not the incorporators, to act as such. And the treasurer is responsible for the certification because the treasurer also signs the articles of incorporation. What does it mean? The treasurer may also be made liable if the information stated on the 7th and 8th clauses are false. I will now skip the others, and I have already discussed, because under section 13, it stated here that there might be other requirements, such other matters consistent with law, like the nationalization laws, which I have already mentioned, and it's already in Attorney Laco's notes, which industries require a particular percentage of Filipino ownership. Also, I've already discussed the arbitration agreement that may be provided in the articles, meaning it's not a requirement, but it's actually preferred because it's the faster way rather than a judicial route. And there's also the electronic filing of the AOI to make it faster. Now, I will now post a picture of the significant changes or the new requirements under the revised corporation code. But before I end On section 13 and 14, please note that the revised corporation code does not provide for a citizenship requirement, and there are actually businesses in the Philippines that are allowed to be owned by foreigners, by 100% foreign owned, like export enterprises. So also under the corporation code, before we end this section 13 and 14, there is no minimum number of directors required. All that is stated is that the maximum number of directors be 15. Yan. So please just take a screenshot of this if you want for quick reference, but everything should also be under Republic Act 11232. Now that we've discussed what must be indicated in the Articles of Incorporation and what must be submitted, let's talk about instances or grounds when the SEC may disapprove of the Articles of Incorporation. So here are the grounds. There are 4 under Section 16, and when the SEC disapproves of the Articles of Incorporation, all is not lost. The SEC must give the incorporators, directors, or trustees or officers reasonable time to modify the objectionable portions of the Articles of Incorporation. So what is reasonable time? It would depend. Because syempre, not all modifications or amendments to the Articles of Incorporation can be done in, say, a day or in 10 days. No? So most of the time, for example, letters A and B, you can already see if the objectionable ground is there just by looking at the Articles of Incorporation. But there are also other instances when the SEC must go beyond the AOI. And what are these? For example, under PD 902A, the SEC may reject the AOI after consultation with the Board of Investment, the DTI, or the NEDA if it is determined that the operation, establishment, or organization of the corporation will be inconsistent with the declared national policies. Another instance is letter C. How will the SEC know that the certification is false? It must conduct an investigation. Therefore, it would need to go beyond the AOI. It would need to look into other documents. And sometimes, even the required Filipino percentage would need further investigation. I will not discuss anymore what these corporations are, no, that must meet the requirement, as I've already discussed that earlier. And don't forget that under the last article, the AOI or any amendments will only be approved by the SEC if there is a favorable recommendation for appropriate government agencies when it comes to these types of corporation: banks and banking, quasi-banking, pre-need insurance, trust companies, NSSLAs, pawn shops, and other financial intermediaries. What are NSSLAs? Non-stock savings and loans associations. So if the SEC disapproves of the articles, since I mentioned that the incorporators are given reasonable time to amend, we shall now look at Section 15 when it comes to amendments. Section 15 talks about general amendments to the AOI. However, the Articles of the Revised Corporation Code also provides for specific instances and specific requirements when it comes to amendments of certain provisions of the AOI. For example, Section 36 talks about amendments when it comes to shortening or extending corporate term, and Section 37 talks about increase or decrease of capital stock. But let's focus first on Section 15. This talks about general amendments. It must be by a majority vote of the Board of Directors and a vote or written assent of the stockholders or members. No? So when you say vote or written assent, if you look at the entire provision, there is no need for a general or regular meeting. It can be by solicitation, say by the board sending a letter requesting the stockholders to either approve or disapprove of any amendments or to interpose their objections to the proposed amendments. And now, how will the amendments look like? It must be underscored, meaning so that it's easy when the SEC looks at it, they can already see, okay, the ones that underlines are the additions. Also, when shall it take effect? It shall take effect upon the approval, which is an express approval, by the Commission, or by an implied approval, which is 6 months from the date of filing the Commission, with the Commission not acting on it. But there is a qualification. The implied approval must be because of a reason not attributable to the corporation. If the failure of the SEC to approve within 6 months is because of the corporation, for example, promises to submit further documents tas hindi naman na-submit within 6 months, then there is no such implied approval because it's the fault of the corporation as to why the SEC did not act for half a year. Okay, now, what are the documentary requirements already stated here? As I mentioned already, the directors or trustees certificate, the amended articles of incorporation, the corporate secretary certificate, and there's an addition, a monitoring clearance. So I'll say that again, a monitoring clearance issued by the Compliance Monitoring Division of the SEC. Another one that might be required is an endorsement or a clearance of the proper government agency, if ever, For example, for the banks, it needs the endorsement of the BSP. Okay. What are the things, although Section 15 talks about amending the articles and it says any provision, the fact that the word any is stated here doesn't mean that talagang any. There are certain provisions that cannot be amended. For example, under the accomplished fact rule, the names of incorporators and their number cannot be changed because once it's written, once they were the incorporators from the beginning, syempre, that's it. They're not you cannot change the incorporators, no? And the same goes for the original directors. Yeah. So that's the accomplished fact rule. You can change the stockholders, the subscribers, but the incorporators you cannot change. Much like how we were born, we can't change who our parents are. Sila na yun. Okay. Now, what else cannot be amended? Amendments cannot be allowed if they go against the nature of the corporation. For example, a stock corporation, its articles cannot be amended to make it a stock corporation. So a non-stock cannot be converted to a stock. But be careful, a stock corporation can be converted to a non-stock. What else is what is the effect of an amendment? Any amendment should not affect the vested rights and the liabilities of the corporations, stockholders, members, directors, trustees, or officers. Since I mentioned kanina that a written assent is needed and there's no requirement for a meeting, it is not for all types of amendments. Since Section 36 and 37 on the corporate term and the change in authorized capital stock are governed by 36 and 37, we must follow the requirements there. And under Section 36 and 37, there must be a regular or a special meeting called for the purpose. So what happens if there's no corporation? Under paragraphs 2 and 3, if there is a corporation, meaning if the SEC finds that the documents are compliant, the SEC shall, so it's a ministerial duty, it does not have any choice, it must issue a certificate of incorporation. From the time that the certificate of incorporation is issued, the date when it was issued or the date stated therein is the commencement date of the corporation. Meaning it is at that point, that's the reckoning point as to when the corporation will have a personality separate and distinct from its stockholders. What happens if there's no certificate of registration? Incorporators and the treasurer, since they are required to sign, ought to know that there is whether there is a certificate of registration or not. They are expected to know under the law that a corporation cannot act without a certificate of registration. Otherwise, there is no separate entity to speak of. But because they ought to know, any actions or transactions that was entered into is still binding, meaning they cannot escape liability just because there is no corporation if they know that the corporation, they know that they have no authority because there's no certificate of registration, and yet they continue to act as a corporation. They are liable. Once that a third party sues them, they cannot suddenly wash their hands and say, oh no, I'm not liable because there's no corporation to speak of. That would be unjust and unfair. So really, this corporation by Estopel, much like a partnership by Estopel, runs on the principle of equity. Please note also that the last paragraph talks about anyone, meaning a third party, is also not allowed to escape liability by merely stating that there's no corporation to speak of. What are these instances? In the Supreme Court case, the third party was a lessor of a property, and he leased the property to the corporation who has not yet been incorporated. So the one who signed the contract was one of the supposed corporation's officers. Because there was no because the incorporation never materialized, the lessor now was running after the personal assets of the officer, stating that, oh, there's no corporation, so you have to pay. The Supreme Court in that case applied Section 20. The Supreme Court said that the lessor is stopped from claiming that the contract was a personal contract of the officer who represented the corporation, since the statements of the party show that it was really meant for the corporation. Another instance also was in the case of Missionary Sisters of Our Lady of Fatima versus Alzona, where there is a deed of donation of a house and lot was executed by the donor before the issuance of a certificate of registration. And in this case, the Supreme Court explained that Estopel applies. The person who has contracted or who dealt with the non-existent corporation is stopped to deny the existence. No? So, since the important keyword here is persons who assume to act knowing that they don't have authority, therefore, there are people part of the incorporation who may not know about the non-existence of the corporation. In those cases, they are liable as regular stockholders and they are not liable beyond their investments. Siyempre, you'd be asking, Miss, you just mentioned they ought to know whether a certificate of registration was issued. That's true for incorporators. And what about subscribers? Again, we mentioned earlier, there may be subscribers and they're not actually required to sign the articles of incorporation, especially when it comes to planned large corporations. There are a lot of subscribers. They're not expected to know the nitty-gritty, and the exact status of the incorporation. So what's next? If it's approved, just look at Section 18. There is the registration, incorporation, and commencement. And then Section 19 talks about de facto corporation. Section 20, we already discussed. Corporation by Estopel. And Section 21 is the non-use of corporate charter and delinquent corporations. Okay. So what is Section 18? I mentioned already the second and the third paragraphs. Let me just go over it quickly. This is how a certificate of incorporation or certificate of registration looks like, issued by the SEC with its seal, already mentioned. So the first paragraph, let me just go over it very quickly. The first paragraph talks about how you should submit the intended corporate name. If you remember the previous slide on the requirements for stock and non-stock, there must be a name verification slip. It's because it's easier to reserve it, no? Yan. Before they submit their AOI. So I will, what needs to be discussed pa about it. Certificate of incorporation is an indispensable requirement. So please forgive me, ang haba na ng video. I might be saying certificate of registration. I mean, certificate of incorporation. Please pardon me. I have not slept. Yan. So, because a certificate of incorporation is essential or required, it is an indispensable requirement before corporate life can actually ensue. A management contract providing for specific benefits to a general manager is not binding on a corporation, diba? What happens? Contracts that were entered before incorporation are usually ratified after the corporation gets its certificate of incorporation. Please note that the certificate of incorporation is only necessary for corporations organized and created under the revised corporation code. Those under the special law don't need a certificate of incorporation from the SEC anymore. Why? Because usually their corporate existence takes effect upon the effectivity of the law creating them. Or sometimes the law will require that conditions be met. Then the corporate entity commences for those corporations upon the compliance of these conditions. Although I just mentioned like management contracts that they are binding on the corporation upon adoption or ratification, there are instances where it may, as an exception, there are some contracts that may be binding even if it's not even before the certificate of incorporation. These are usually pre-incorporation subscription agreements. The revised corporation code clearly states, and we will discuss that later when we go to section 60, that the pre-incorporation subscription agreement is irrevocable for a period of 6 months. So what else? For promoters, there are contracts that bind the corporation, although as a general rule, again, it is not binding, no? So it is just in certain situations where a promoter's contract binds a corporation. These exceptions where a promoter's contract is binding under as an exception is when the corporation is deemed to have expressly or impliedly ratified the acts of the promoters. What do you mean by implied ratification? They accepted the benefits. Okay. Section 19, de facto corporations. The operative word here is that the people acting for the de facto corporation act in good faith. A de facto corporation is different from a de jure. A de jure corporation, which I already discussed in the introduction, is a corporation that complied with everything under the law or substantially complied. What if there's no substantial compliance? If the incorporators or the persons behind the corporation act in good faith, they are de facto. The difference between a de jure and de facto, aside from that, is that a de jure corporation cannot be its existence cannot be assailed or questioned or attacked even by the government. In de facto corporations, the only entity that may attack or question or to question the existence of a de facto corporation is the government, and it's only through a quo warranto proceeding. A quo warranto proceeding is provided for under the rules of courts. You don't need to know that anymore. What you need to do, you need to understand when it comes to this section is that private or other persons, meaning as long as it's not the government through the Solicitor General, cannot question the existence of a corporation collaterally. Okay. These de facto corporations are actually defective corporations. So these are instances when they did not comply with the mandatory provisions. But there is either they did not comply or they did not substantially comply, So again, I will just stress this again. The non-compliance, say the issuance of a certificate of incorporation is a condition precedent, and therefore there can be no de jure corporation without a certificate of incorporation. When you say non-compliance, we're talking about mandatory provisions. Sorry, I may be repeating myself. I just want to clarify. If the corporation does not comply with directory provisions, meaning provisions of the law that are not really required, then that is still a de jure corporation. So be careful with that. What if the corporation fails to comply with conditions that are required to be complied with after incorporation? That does not affect the existence of a corporation. It's still a de jure corporation. So again, what are the requisites of a de facto? Under Section 20, 1, there is a valid law under which the corporation is organized. 2, there is an attempt in good faith to incorporate. And 3, there is an assumption of corporate powers. What do I mean by valid law? If there is a valid law, and then later on there is a law saying that it's not anymore legal to have a certain type of corporation, then that corporation cannot say that it's de facto, because if the law granting it suddenly is revoked, there's no valid law anymore, then it cannot be a de facto corporation. Why? Because a de facto corporation is actually almost de jure. So if there's no valid law, then it can never actually be a de jure corporation. I hope I make sense, no? Please just message me if hindi nyo naintindihan. So what is good faith? There is an evident attempt to comply with the law. So it can be shown, it can be proven that they attempted to comply with the law. There is usually we'll see the words colorable compliance. Not substantial compliance, but colorable compliance. For example, the corporate name resembles the name of a pre-existing corporation, or one or more of the incorporators are ineligible to be incorporators, or one of the purposes is not authorized by law. So there's still a de facto corporation as long as the people behind the corporation execute corporate acts. What do you mean by corporate acts? These are acts that, acts that talk about when you say corporate acts, business acts, the running of the business of the corporation already, meaning these are not acts relating to the formation or corporation or incorporation, no? Or they are not the mere organization or the election of the officers. That's not a corporate act contemplated here. When we say corporate acts, they're really doing business already. A de facto corporation enjoys the attributes of a corporation until the state questions its existence. You may be asked, what if there is no filing of the bylaws? There's a Supreme Court case, but I don't agree with that, no? The Supreme Court stated that it is considered a de facto corporation, but a de facto corporation kasi means that it failed to comply substantially or fully with the requirements at the beginning. But, and we will talk about this later on, the filing of the bylaws is a condition subsequent. So at the time of the filing of the Articles of Incorporation, although I already stated that you must file the bylaws, it's not really mandatory. You can actually follow it up. Yan. And so again, just to be clear, when it comes about when we talk about a valid law, a corporation was created by a special law. Later, the law creating it was declared invalid. May the corporation claim to be a de facto corporation? No, the corporation is not a de facto corporation. The requisites for its existence are absent because there is no valid law. Therefore, there can be no continuity of good faith. That is from the 1994 bar exams. Okay, last. What are delinquent corporations? There are two types of corporations contemplated under Section 21. One is a corporation that does not formally organize and commence its business within 5 years from the date of its incorporation. So in those cases, the certificate of incorporation is deemed revoked on the day after the 5-year period. So in these cases, they were granted certificate of incorporation and they did nothing further. What if the corporation already did business, executed corporate acts, and then it stopped? In those cases, from the time that it becomes inoperative, you count a period of 5 years. If after 5 years from the time that they stopped, wala pa rin, there's still no business that was conducted, the revocation is not instantaneous. The commission first shall issue notice and have a hearing before that corporation becomes delinquent. So when you talk about delinquent corporations, you're really talking about this second paragraph, no? So what happens? A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements stated by the commission. How will you know the requirements? Here, in the hearing, and in the due notice. Okay, what if they fail to comply pa rin? Then their certificate will be revoked. There. So that is Title 2. Is there anything that I missed? Wait lang, before we all yay here. Okay. Just take note that although it states here that if the business does not formally organize, it shall be deemed revoked. So when you say deemed revoked, it sounds automatic. To a certain extent, it is, but the dissolution is really not automatic in a sense that the SEC still needs to conduct an investigation to see if the corporation is already exercising its powers. Yeah, so in an SEC opinion, it said that usually they will conduct proper proceedings for the revocation pa. Kasi they also need to determine in an appropriate proceeding if the life of the non-compliant corporation ended already, if the 5-year period has already ended. So, again, if I may stress, what do you mean when you say commencement of business? If it has performed preparatory acts geared toward the fulfillment of its purpose. Okay? So, such as entering into contracts for negotiation or lease or purchase of property to be used, making plans for and construction of the factory, taking steps to expedite the construction of the company's working equipment. Okay, here, there's a problem I just want to read before we end. In the Articles of Incorporation, 11 members were constituted as the board. These 11 elected among themselves a secretary-treasurer but did not elect a president. So the board used to hold meetings, which was done through the secretary-treasurer. Now, the question was the corporation formally organized? The answer is yes. It is considered formally organized because the corporation had a governing board which directed its affairs as well as a secretary-treasurer. The corporation actually functioned and engaged in the business for which it has been organized. So that's in the 1979 bar. So there we finished Title 2. My apologies for those who might have been confused. Please feel free to message or email me and I will see you in the next video. Bye!